Good evening, and welcome to our special broadcast. Tonight we delve into a profoundly significant and often contentious issue at the heart of American constitutional debate: reconciling the Second Amendment right to keep and bear arms with escalating concerns over public safety and gun violence. The central question we'll be exploring is whether stricter gun safety laws, proposed with the intention of saving lives, fundamentally violate the protections guaranteed by the Second Amendment. Joining us to dissect this complex legal and societal challenge are two distinguished guests. Senator Isabella Rossi, a vocal proponent for enhanced gun safety legislation, arguing for their constitutionality and necessity, and Mr. Mark Chen, a respected constitutional lawyer, who contends that such measures represent an infringement upon fundamental Second Amendment rights. Our format tonight will consist of opening statements from both Senator Rossi and Mr. Chen, followed by a moderated discussion where they can respond directly to each other's points, and concluding with closing remarks. We anticipate a rigorous, yet respectful exchange on this vital topic.
Thank you, Dr. Reed. Let me begin by unequivocally affirming the existence of the Second Amendment right. However, like all constitutional rights, it is not absolute, nor was it ever intended to be a carte blanche for any individual to possess any weapon under any circumstance. The very text of the amendment, mentioning a, quote, well-regulated militia, signifies the framers' understanding that this right operates within a framework of communal safety and governmental oversight. It's not merely an anachronistic preamble. It informs the scope of the right itself. The Supreme Court, even in landmark decisions like Time District of Columbia versus Heller, which affirmed an individual right to possess a firearm for traditionally lawful purposes such as self-defense in the home, explicitly stated the right is not unlimited. Justice Scalia's majority opinion in Heller specifically mentioned long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places like schools and government buildings, as presumptively lawful. This clearly indicates a constitutional space for regulation. Furthermore, New York State Rifle and Pistol Association, Inc. versus Bruin, while establishing a new test focused on text, history, and tradition, did not obliterate the possibility of regulation. It demands that regulations be consistent with the nation's historical tradition of firearm regulation, a tradition that does exist, contrary to absolutist interpretations. When we advocate for stricter gun safety laws, we are referring to specific, evidence-informed measures, universal background checks to close dangerous loopholes that allow prohibited persons to acquire firearms, restrictions on high-capacity magazines designed for mass casualty events, and prohibitions on certain semi-automatic firearms, often termed assault weapons, which are designed for rapid, widespread harm, far exceeding typical self-defense needs. We also support red flag laws, or extreme risk protection orders, which allow temporary removal of firearms from individuals demonstrably posing a significant danger to themselves or others, subject to due process. These are targeted interventions, not blanket confiscations. The data correlating the implementation of such laws with reductions in gun deaths and injuries in various jurisdictions is compelling. This isn't about disarming law-abiding citizens. It's about establishing reasonable safeguards that balance individual rights with the collective, fundamental right to live free from the pervasive threat of gun violence. Achieving this equilibrium is not only possible, but constitutionally sound and morally imperative.
Thank you, Dr. Reed. Senator Rossi presents a view that, while perhaps well-intentioned, fundamentally misunderstands the nature and scope of the Second Amendment. It is not a right granted by the government, but a pre-existing fundamental right of the individual, enshrined in the Constitution, primarily for the purpose of self-defense, a cornerstone of individual liberty. The Supreme Court in Heller unequivocally affirmed this individual right, separate and apart from militia service. The well-regulated militia clause, historically understood, referred to the body of the people capable of bearing arms, ensuring they were equipped and disciplined, not a justification for governmental restriction of the core right itself. Attempts to interpret the militia clause as a limitation fundamentally invert its historical purpose, which was to ensure the citizenry could resist tyranny if necessary and maintain their own security. The right belongs to the people, not the state. Let's examine the specific laws Senator Rossi advocates. Bans on so-called assault weapons typically target modern semi-automatic rifles, which are among the most popular firearms in America, owned by millions of law-abiding citizens for lawful purposes, including self-defense, sport shooting, and collecting. They are precisely the types of bearable arms protected under Heller. Universal background checks extending to private transfers between individuals impose significant burdens on lawful gun owners, potentially criminalizing previously routine activities without demonstrably preventing criminals who inherently disregard laws from acquiring firearms through illicit means, such as theft or the black market. Red flag laws, while aiming at a laudable goal, often lack robust due process protections. Individuals can be deprived of their constitutional rights based on asterisk ex parte proceedings, often requiring them to prove their innocence later to regain their rights and property. This flips the presumption of innocence on its head. The assertion that these laws significantly enhance public safety is highly debatable. Correlation does not equal causation, and crime is a complex issue influenced by myriad socioeconomic factors. These laws primarily function to disarm responsible citizens, potentially leaving them more vulnerable, while doing little to determined criminals who will always find ways to obtain weapons. Ultimately, these proposed stricter regulations represent a significant governmental overreach, chipping away at a fundamental constitutional right under the guise of safety. They punish the law-abiding for the actions of the criminal, which is antithetical to our system of justice and liberty.
Thank you both for those comprehensive opening statements. Mr. Chen, let me start with you. Senator Rossi referenced Justice Scalia's opinion in Asterisk Heller, which explicitly mentioned presumptively lawful regulations like prohibiting felon possession or carrying in sensitive places. How do you reconcile this acknowledgement of permissible regulation with your assertion that many proposed stricter laws are inherently unconstitutional infringements? Where is the line drawn?
That's a crucial point, Dr. Reed. The Heller Court acknowledged long-standing, narrowly defined prohibitions directly tied to preventing misuse by demonstrably dangerous individuals, felons, mentally ill, or in specific, sensitive locations. These historical exceptions are fundamentally different from broad prohibitions on entire classes of commonly owned firearms, or imposing universal background checks that burden every transfer. The line is drawn based on the Heller and Asterisk Bruin standards. Regulations must align with the text, history, and tradition of firearm regulation in the United States. Banning the most popular rifle in America, the AR-15, finds no historical analog and directly contradicts Heller's protection of arms in common use for lawful purposes. Universal background checks on private sales lack deep historical roots.
If I may, Mr. Chen, the historical analysis isn't quite so straightforward. While specific models like the Arkansas 15 didn't exist, the type of weaponry available and its potential impact have drastically changed. The framers could not have envisioned firearms capable of inflicting mass casualties with such rapidity. The Bruin court itself acknowledged that historical analogies might be necessary for modern regulations. Surely the tradition of regulating dangerous weapons, like machine guns, which were heavily regulated by the National Firearms Act of 1934 despite being, quote, provides a relevant historical analog for regulating weapons with similar characteristics today, such as semi-automatic rifles with high-capacity magazines.
Senator, the National Firearms Act primarily involved taxation and registration, not outright bans on possession by law-abiding citizens, and it targeted weapons like machine guns and short-barreled shotguns, which were far less common and functionally distinct from the semi-automatic firearms targeted today. Applying that analogy is tenuous at best. Furthermore, focusing solely on the weapon ignores the user. Millions lawfully own these rifles and never misuse them. Blaming the tool distracts from addressing the root causes of violence, such as mental health crises, socioeconomic disparities, and failures in enforcing existing laws against prohibited possessors.
Senator Rossi, Mr. Chen raises the point about the burden on law-abiding citizens. Critics argue that measures like universal background checks, while perhaps well-intentioned, disproportionately affect lawful transactions. Say, selling a hunting rifle to a neighbor, without significantly hindering criminals who operate outside the legal system. How do you respond to that concern?
The data suggests otherwise. States with universal background check requirements consistently show lower rates of gun trafficking and fewer firearms diverted to the criminal market. The inconvenience for law-abiding citizens, typically a small fee and a short wait at a licensed dealer, is minimal compared to the potential benefit of preventing even one firearm from falling into the wrong hands. It's about closing a gaping loophole. Why should a person legally prohibited from buying a gun at a licensed dealership be able to simply purchase one online or at a gun show from a private seller with no questions asked? It defies common sense and undermines the entire background check system we already have in place for licensed dealers.
The gun show loophole is largely a myth. Licensed dealers operating at gun shows already must perform background checks. The issue is private sales, and while the senator minimizes the burden, it represents a significant shift, requiring government permission for private property transfers between law-abiding individuals. Moreover, criminals, by definition, do not follow the law. They will continue to acquire firearms through theft, straw purchases, which are already illegal, and black markets, regardless of universal background checks. The focus should be on prosecuting these illegal activities, not adding layers of regulation on lawful ones.
Let's turn to the Chalm-Bruin decision's emphasis on text, history, and tradition. How does this standard apply, in both your views, to modern firearms like AR-15 style rifles? Senator, you suggested historical analogy. Mr. Chen, you argued they are protected as, quote, common use. How should courts navigate this?
Courts should look at the asterisk function and asterisk purpose, historically regulated. The tradition wasn't just about specific models, but about regulating unusually dangerous weapons, or ensuring firearms weren't carried in ways that threatened public order. Firearms designed for military-style assault, maximizing rapid casualties, arguably fall into a category historically subject to potential regulation, even if the specific mechanism is modern. The analogy lies in the danger posed.
Respectfully, the Bruin standard is clearer. Is the conduct, keeping and bearing arms, covered by the Second Amendment's plain text? Yes. Then, is the regulation consistent with the nation's historical tradition? Banning the most common type of rifle owned by millions for lawful purposes is demonstrably not consistent with that tradition. Heller protected arms in common use, and these rifles undeniably fit that description today. The focus must be on the weapon's typical use, not its potential misuse or cosmetic features.
Senator Rossi, regarding red flag laws, Mr. Chen raised concerns about due process. How can these laws be implemented effectively while ensuring individuals' constitutional rights are adequately protected against potential misuse or erroneous reports?
Robust red flag laws incorporate strong due process protections. This includes requiring specific evidence of significant danger, providing prompt post-deprivation hearings where the individual can contest the order, representation by counsel, and penalties for false reporting. The temporary removal is precisely that, temporary, and predicated on preventing imminent harm. It's a crisis intervention tool, not a permanent deprivation without due process.
The initial Ex Parte A order, however, remains deeply problematic. Removing someone's fundamental right based on allegations before they have a chance to respond is a serious departure from standard legal practice. While post-deprivation hearings exist, the damage, seizure of property, stigma, potential legal costs is already done. The potential for abuse, particularly in contentious personal disputes, is significant and requires extremely high evidentiary standards from the outset.
Mr. Chen, beyond opposing stricter regulations, you mentioned alternative strategies. Could you elaborate on what you believe are more effective approaches to reducing gun violence that respect Second Amendment rights?
Absolutely. We should vigorously enforce existing laws, ensuring prohibited persons are actually prosecuted for attempting to acquire firearms. Investing in mental health care access and early intervention programs is critical. We need community-based violence interruption initiatives that address the root causes of violence in affected neighborhoods. Secure storage campaigns can reduce accidental shootings and theft. Focusing on these areas targets the actual drivers of violence, without infringing on the rights of millions of law-abiding Americans. Throughout this discussion, the fundamental principle remains clear. The Second Amendment guarantees an individual right to keep and bear arms, a right essential for self-defense and personal liberty. The measures proposed by Senator Rossi, while perhaps presented with good intentions, ultimately constitute a significant infringement upon this core constitutional right. Bans on commonly owned firearms, burdensome universal background checks on private transfers, and red flag laws with questionable due process protections do not align with our nation's history or legal traditions as affirmed by the Supreme Court. They disproportionately impact law-abiding citizens, treating them as potential criminals rather than rights holders. Furthermore, the evidence supporting the efficacy of these laws in preventing violent crime is ambiguous at best, often ignoring the complex realities of criminal behavior and the myriad other factors contributing to violence. Criminals, by their nature, disregard laws. These proposals mainly serve to restrict the freedoms of the responsible majority. Instead of pursuing constitutionally dubious restrictions, our focus should be on enforcing existing laws, addressing mental health challenges, prosecuting violent criminals, and promoting responsible gun ownership. Protecting public safety and upholding constitutional rights are not mutually exclusive goals, but achieving both requires solutions grounded in reality and respect for fundamental freedoms, not broad restrictions on law-abiding citizens. Thank you.
Dr. Reed. Mr. Chen, thank you. We must remember that no constitutional right is absolute. The Second Amendment, like the First, can and must coexist with reasonable regulations designed to protect public safety and save lives. This is not a radical concept. It is firmly rooted in our legal tradition and acknowledged even by the Supreme Court decisions often cited by opponents of regulation. The measures we advocate: universal background checks, restrictions on weapons of war and high-capacity magazines, and carefully implemented red flag laws are not attacks on responsible gun ownership. They are targeted, common-sense steps aimed at reducing the horrific toll of gun violence that plagues our communities, our schools, and our homes. The societal cost of inaction is measured in thousands of lives lost each year, families shattered, and communities living in fear. While enforcement of existing laws and mental health initiatives are vital components of any comprehensive strategy, they are insufficient without also addressing the easy accessibility of firearms, particularly those designed for mass harm, to individuals who pose a danger. These proposed laws are constitutionally sound, drawing on historical precedent and the state's compelling interest in protecting its citizens. They represent a necessary balancing act, striving for an equilibrium where individual rights are respected alongside the collective right to safety and life. It is time for legislative action grounded in evidence, public health, and a commitment to a safer future. Thank you.
Senator Rossi, Mr. Chen, I extend my sincere thanks to both of you for engaging in such a substantive and illuminating discussion on this incredibly complex and sensitive topic. You've articulated your positions with clarity and conviction. Tonight we've heard compelling arguments centering on the interpretation of constitutional text and historical tradition, the delicate balance between individual liberties and the imperative of collective safety, and differing views on the practical efficacy and constitutionality of specific gun safety proposals. The questions raised tonight do not have easy answers, and the debate reflects deep divisions within our society. We hope this discussion has provided valuable perspectives and encourages our viewers to continue engaging thoughtfully and respectfully with this critical issue. Thank you to our distinguished guests, and thank you to our audience for joining us. Good evening.